Hello everyone, my name is Hina Belitz and this is a video about the contract of employment. A short while ago I did a video on compromise agreements and it was so well received. A lot of people, clients, new contacts commented on how helpful they found it was, and that's the reason why I've decided to do a series of them, starting with the contract of employment. Now this particular video is just a highlight or a taster of some of the important things that people ought to know, companies and individuals alike, about contracts of employment, and often some things that are often missed as well or not fully understood. There are 7 things, so this is about the 7 key points that people should understand about contracts of employment. Now the first one that I'm going to start with is the Section 1 of the Employment Rights Act. And this is something, again, everyone should know, is that the law prescribes or requires that a certain number of clauses or points are included in every contract of employment. And those are basic terms and conditions like name and the parties and so on. But it's also, it does include the one that tends to catch people out is the collective agreements. A lot of people will ask, well, why is there reference to there being no terms contained in a collective agreement in my contract? And the reason why Section 1 requires mention to be made. The second point is the deductions clause. Now this is an incredibly important clause because people have found themselves, companies that we advise have found themselves in great difficulty because they are terminating someone's employment and yet that person owes them a sizable amount of money, whether it's a season ticket loan or a course they went on. And we have to actually advise that without a deduction clause you can't actually deduct money they owe you from what you owe them. So say for example you owe them £2,000 as payment in lieu of notice on departure or in relation to any other monies due to them, and they owe you £1,000. You can't actually just say, well, we're paying you £1,000 because we've deducted the £1,000, which sounds really illogical, but it is an unlawful deduction if you do that, unless you've got a contractual deduction clause. So that's an important point to note, and it does feature quite heavily in a lot of the litigation that we find ourselves involved in, especially assisting employers. It tends to be something that tends to come up quite a lot. The next point is really just a small one to mention that there is a remedy, or at least there's a sanction legally for failing to provide a written statement, a Section 1 statement, within 2 months of employment. It isn't a standalone right, so you can't actually just bring a claim, or an employee can't bring a claim in relation to it. But if they have, for example, an unfair dismissal or a discrimination claim, they can say, and 4 weeks extra in their claim form for failure to provide a written statement of employment. So that's something to just bear in mind. And I know a lot of people can quite easily fall foul of that requirement. Number 4 is the discipline and grievance procedure, because of course a lot of the work we do will derive from or involve in some way a disciplinary procedure or a grievance that's been raised. So I would say that the key thing really with contracts is they should make reference to where a disciplinary procedure can be found or where the disciplinary and grievance procedure is. Some of them will actually include a copy or make reference to it in a handbook, but not every employer has a handbook. Obviously if you've got it on the intranet you can refer to it there, or if it can be obtained from HR that can be included. But it is quite important because it's quite amazing how often disputes will centre around these issues, like, well, I was never told about this, or I didn't know where I could find it, or the version I got wasn't what I'd been given before, or all manner of disagreements and disputes of that sort. Number 5 is termination of employment. As you can probably imagine, a lot of the work we do centres around the clauses on the termination of employment, and what we tend to find is that clause is very important on several levels, not least alongside, by the way, the payment in lieu of notice clause, or a PILON clause as it's called in brief. The termination provisions will include things like the notice and whether or not payment can be made in lieu of notice, how much notice there is, and it is important because it can impact the enforceability, whether or not it's properly dealt with and properly reflected in the agreement, can impact whether or not post-termination restrictions remain enforceable, and it can also have other impacts. Basically, just explaining that point further, a payment in lieu of notice clause will impact tax, but also if there is a payment in lieu of notice clause in the contract, you can actually pay someone instead of have them serve their notice, and their post-termination restrictions remain intact. If you were to pay someone in then the notice money, but there is no payment in lieu of notice clause, there's a risk that the post-termination restrictions will no longer be enforceable, because it's a technical breach of contract to pay someone when the contract doesn't provide for payment in lieu of notice, but only provides for someone working their notice. So that's quite important, and of course there are tax ramifications on how you can treat notice, and with reference to the 30,000 that can be paid tax-free on termination. Number 6 is the variation of contract. This is an interesting area, and one that again we see quite a lot, and I think one that is probably very misunderstood, because a lot of employers and employees alike are not aware of the fact that you can lawfully vary someone's contract of employment. Now, people will often be confused by the fact that there is within a contract often a variation of contract clause that says we have reserved the right to vary this or that, or a general variation clause. Now, the truth of the matter is that that clause is not actually very powerful or significant. It's relevant in that, it being there can assist, but if you really wanted to vary someone's contract, there is a legal way that you can do it, as long as you have got good sound business reasons for doing so. And so, people think, oh, you just can't. Well, you can't unilaterally impose a change, but you can lawfully effect a change in the contract of employment by following a procedure, provided it's a good sound basis for doing it. So, of course, if anyone needs further input on that, let us know, because that is one that tends to catch a lot of people out. And my final point is updating contracts and post-termination restrictive covenants. And I can certainly say that of the banks, companies, financial institutions that we advise, and the senior level executives and bankers, this is probably one of the biggest areas of advice that we provide. Post-termination restrictions are those clauses in the contract that continue to apply after the contract has ended. So, for example, that you will not, for a period of X number of months, maybe 6 months, poach staff or approach clients, or deal with clients. You will not contact suppliers. It's those sorts of provisions, and it also includes things like confidentiality, etc. So, very important clauses, very often misunderstood clauses as well. A lot of people think, well, how can they do this to me, because they should surely have to pay me. Well, garden leave is paid, but post-termination restrictions on the basis of certain factors applying can have legal force even though you don't get paid during the period of a restriction as an individual. The other thing, of course, is that we often come across situations where someone very senior is leaving, either we're effecting a dismissal, or we have an individual that has decided to leave for other reasons. And if they've been a long time in the company, there'll often be many years where they've never been provided with an updated contract, and so you do often have a situation where the contract that they're looking at to be advised on for leaving is woefully inadequate from the company's point of view, because it contains no restrictions, and yet this person over the years may have got quite a lot of control, seniority, access to contacts, and is in essence an ability to damage the business if that element of protection does not exist. So it's very important from both points of view to give careful consideration to post-termination restrictions. Of course, this is just a brief review of 7 key points. There are lots of others that are inevitably important and significant that arise in contracts of employment. If anybody wants further advice or would like to have an informal chat about this, feel free to give us a call, and thanks very much for watching.